Okay, welcome back. This is video 2 of the post-decree, post-order modification and/or enforcement case initiation videos. In this second video, I'm going to talk about the issuance of the order to appear and serving the papers. So we're going to go through steps 2 and 3 in this video. So in this step, the issuance of the order to appear, this is where the judge reviews the petition to modify and/or enforce and decides if there are sufficient grounds to set a hearing. Once the petition and proposed order to appear are filed, Rule 91I explains that the court can set a conference or hearing or reject the petition. So upon receipt of the petition and proposed order to appear, the court must review the petition and either reject the petition for failure to state grounds upon which relief can be granted, or issue the order to appear. If the court rejects the petition, the court needs to explain to the applicant what the deficiency was, provide them with an opportunity to correct it, and a deadline to do so. In deciding whether to reject the petition, the court cannot assess the credibility or weigh evidence. If the court issues the order to appear, it must set a resolution management conference or evidentiary hearing as appropriate. No evidence may be taken at the resolution management conference except under emergency circumstances. So the court gets to decide based on what's in your petition, whether or not the court's going to grant a hearing. And if the court grants a hearing, it's going to be a resolution management conference or an evidentiary hearing. And we'll talk about that more in the videos in this series. Here's another part of this Rule 91I about what counsel is required to do, and then the scope of the resolution management conference. So those are just some additional parts of the rule, but the bottom line is once you file, the judge is going to review your petition and decide whether or not your case moves forward. If the judge is finding that your case shouldn't move forward, the judge is supposed to give you an opportunity to correct it with a deadline. If the judge finds cause to move forward, the judge sets a hearing. So post-decree, post-order procedures are different. You know, this is in other cases, in pre-decree or pre-order, you don't file this order to appear. The judge doesn't review the petition and decide whether you get a hearing. Pre-decree, you file your petition, you serve it, the other side has 20 days or 30 days to respond, and you go forward from there. So post-decree is different. This is where the petition's filed and then the judge sets a hearing if it's merited, and then the case moves forward from there. All right, let's talk about step 3. So this means you filed your petition and the court issued the order to appear, meaning the court either set a resolution management conference or a evidentiary hearing. So at that point, once you have the completed order to appear, you're going to need to serve that with your petition and all the other papers you filed on your opposing party. So you have 3 options: acceptance of service, certified restricted mail, or hiring a process server. So once the order to appear is issued by the court, you have to serve the papers, and you're supposed to make a good faith effort to complete service promptly and within 10 days of receiving the issued order to appear, but you must complete service in no event later than 20 days before the hearing. So calendar those days, those are your service deadlines. Okay. Option 1 is the acceptance of service. So for the acceptance of service option, you would make a copy of each pleading you filed to initiate your case. Draft and print out the acceptance of service form, which I'll show you in a minute. Meet with your ex-spouse or co-parent and a notary or a court clerk. Hand your ex-spouse or co-parent a copy of each pleading you filed to initiate your case. Have them sign the acceptance of service before the notary public or court clerk, and then you e-file the completed acceptance of service form with the court. So you need cooperation with the other side. You need to make time to meet together before a notary or a court clerk in order to accomplish service using the acceptance of service form. Here's what it looks like. Fill out your caption, and then select your type of case, which is going to be modification. So if you're looking to modify spousal maintenance or child support, check here, child support only, child support. So simplified procedure, we talked about that in last week's video. Here, what we're talking about here, this would be the standard modification process for child support, modifying parenting time, legal decision-making parenting time and child support, income withholding order, stop income withholding order, post-decree mediation. So these are all, you would check, you'd find what box applies in your case and then check these boxes for all of the papers that you filed to initiate your case, that you're providing a copy to the other side, that they're now signing this acceptance of service, acknowledging receipt of these papers. This is where they would sign saying, yeah, I received these papers. Okay, so that's the acceptance of service. A second option is certified restricted mail. So in order to take advantage of this option, you would again make a copy of each document you e-filed to initiate your case, mail the copies of each document to your ex-spouse or co-parent via certified restricted mail. If your ex-parent or ex-spouse or co-parent signs the green card, then e-file an affidavit of service via certified mail and include a copy of the signed green card. You can also include a copy of your receipt for the certified mailing. So here is what the affidavit of service with signature confirmation, this is what they call it in Maricopa County. I often call this form affidavit of service via certified mail, but this is just showing all the information about your certified mailing, indicate what documents you served, and then signing it before a notary, including a copy of the signed green card, including a copy of your receipt. You can also include a copy of the tracking information from the post office webpage when you put the tracking number in. That's another option. Okay. All right. Now we have a question, and the question is, what about e-file system and its use in notification? Well, that is different because when you're at that notification stage, that's when both parties are participating in the case. At this stage that we're at right now, a new petition has been filed, and now the other side has due process rights to be properly served with that petition through one of these methods. If they then are served and start participating in the case, then you can start doing service through the e-filing system if everyone's in agreement with that. But at this point, they don't even know there's an open case unless you've told the other side. But theoretically, you filed and they don't even know this case exists. So they're not checking, they're not entitled to service through the system. They need to be served according to the court rules. All right, now if the acceptance of service isn't working for you, you tried certified mail and they just ignored it, didn't sign it, refused it, then you can look into hiring a process server, or maybe you go to this option first, depending on your situation. To hire and work with a process server, find a process server in your area, find a process server where the person you're going to serve, where they are. Additionally, you can contact law enforcement where they are and work with the civil process server within the law enforcement department. Provide the process server with information to locate your opposing party, their address, what they look like, where they work. Provide the process server with copies of the pleadings you filed in your case that they need to serve. So you can email those to them and they print them out, or drop off copies to them, whatever you guys work out. And then once service is complete, make sure the process server e-files an affidavit of service or that you e-file the affidavit of service if the process server you hire does not handle the e-filing. So service gets done, but then you need to tell the court it's been done. And you tell the court by filing this affidavit of service. Here's what an example of a process server information form looks like. Now, this doesn't get filed with the court, but this is something, and you can see that this is created for a sheriff's office. But, if you work with a private process server, they might have their own form they ask you to fill out. But it provides them with information about what the other side looks like and addresses where they can be found. So you can use this if that's helpful for you in the process server you're working with. What if you can't find the other party or they're avoiding service? What do you do with service at that point? Well, first you have to make diligent efforts to try to serve your co-parent. So you need to hire a process server and give it a try. You need to try certified mail. You need to try to communicate with your co-parent. Now, if you don't know where they are, you may need to hire a private investigator to locate information about your missing co-parent. You have 120 days. Now, I needed to change this part. You don't have 120 days. So I'm going to correct that. I apologize. We went over, you need to serve this within 10 days of the order being issued, and at the latest 20 days before the hearing date. So this is going really fast. And if you're unable to complete service by the time you get, and your hearing's coming up, you'll need to file a motion with the court, asking the court to extend, to move the hearing date out to give you additional time to try to complete service. So if you just know you're not going to be able to find your ex-spouse or co-parent, then you'll make your diligent efforts, and then you can ask the court to grant you permission for alternative service, which can be email, social media, text, or this option to publish in a local paper. So here's the motion to seek alternative service or publication. So you just fill this out based on your case and the attempts you've made. And then here's the proposed order. Now, for most cases, you're going to know where your co-parent is because you've been co-parenting together. So this is going to be rare where you're not going to be able to find your co-parent for service. However, if they're avoiding service, this alternative service option via email, for example, can be really helpful. Okay. All right. Now, if you do end up using the publication, this is a declaration you can use to show you completed service by publication. And then let's just review your options for service of process. So there's the acceptance of service, the certified restricted mail, the process server, and then the motion for alternative service and or publication. If your co-parent or ex-spouse is avoiding service or you can't find them. Okay, and then as a reminder, in the following types of cases, the parties must file and exchange affidavits of financial information no later than 20 days after service, unless the court sets a different date. So this would be for a petition to modify spousal maintenance, a petition to modify child support, or if either party is requesting an award of attorney's fees and costs. Okay, so that brings us to the end of this section on the issuance of the order to appear and the how to serve the papers once the order to appear is issued. In the next video, we're going to talk about the response to the petition to modify or enforce. It's optional. You don't have to file a response. So we're going to talk about the ins and outs of that. And also, if you do want to file a response, we'll show you how that's done.